Hi, I'm Michael Cohen. I'm a Dallas elder and estate planning law attorney. I'm joined by my friend Don Crawford Jr., who for many years we did a radio show together, and we're continuing with the next generation of radio shows. That is, we're doing this by YouTube and podcast. So thank you, Don, for joining me. He always asks questions, and we're just continuing that.
My pleasure.
Today, Don, we're going to be talking about, as we know, Rob Reiner and his wife were killed by their son, Nick.
Nick.
And of course, he hadn't been convicted yet. I'm sure there'll be lots of things that'll go on between now and whenever there's a trial. But we're saying, can his son, Nick, benefit from killing his parents? And what are the differences between the laws of California and Texas? Now, I'm not licensed in California, and I'm not going to go to say specifically, but the laws of California say in their statute, if you feloniously and intentionally kill somebody, you shouldn't benefit.
Good.
So that means if you, uh, are convicted for murder, okay, you do not get anything from a trust. You don't get anything from a will. You don't get anything from a beneficiary designation. You don't get anything. You don't benefit from killing your parents.
Are there other states? Is the implication that allow that?
Most states have what's called
Oh,
Slayer statutes, but they vary. There's three different types. But most of them do. And I can't tell you about every state. I can tell you a little bit about Texas. But, so the question then, because it says feloniously and intentionally, what if Nick was not convicted of a felony? But apparently, it looks like in the laws of the state of California that it seems like even if it was a civil matter, that it also means that he would not benefit. Think of O.J. Simpson. O.J. Simpson murdered, we think, we uh, Nicole Brown Simpson and Ron Goldman. He was not convicted of a felony. But in a civil judgment, he got a big judgment against him in a civil court. In a criminal court, the level of evidence needed is beyond a reasonable doubt for conviction. Whereas in a civil court, if somebody sues, you have to just prove by a preponderance of the evidence. In OJ's case, and I would assume it would be similar here, that even if he was, because remember, Nick had been in rehab probably, I think it was over 18 times. He had addiction issues. So he's been a problem for a while. So could his attorney, which is a very high-powered attorney, say, well, he's not guilty because of his mental state? Now, I should say, who pays for that attorney? Remember, he hasn't been convicted yet. So it could be that his trust, let's assume that they lived in California in Brentwood, and in California, since they have a more difficult probate system, it's likely, although I don't know for sure, that he has a trust to avoid, because the laws are so onerous in California. It takes years to probate in California. So it's likely that Rob Reiner had a trust. Now that's private, but remember, he hadn't been convicted, and you would think that not only would he might be able to get some of the funds, Rob Reiner had a $200 million estate. He might be able to use to get attorney's fees possibly. Uh, and he could either argue to the court, I haven't been convicted, or something, I would think his attorney would say.
sure.
And also, he'd have a right to look at the documents. There's nothing that says it prevents him from looking at the documents. He cannot serve uh, as a fiduciary, a trustee, an executor, agent under a power of attorney that we talked about on a previous podcast if you've been convicted. So I think that the laws of California, the intent is clear. You can't benefit from killing a parent.
I think he has siblings too, does he not?
Yeah, he's got two from this marriage, and Rob Reiner adopted a child with Penny Marshall,
Oh,
from
wow.
a prior marriage, who is a lot older. So they would all perhaps get less if they took money from the trust. They may
Right.
want that to so that he for his, maybe his rehab or something in the future. But everybody is a loser when it comes to this. Now, I should say, if let's say somebody killed somebody in self-defense, that might be a different story. We're
Right.
talking about murder that was intentional. So they use the word intentional because, there'll be situations where some people have self-defense. Now, interestingly enough, I told you that laws vary from state to state. In Texas, our statute only deals with life insurance. In other words, you can't benefit by killing somebody to get the life insurance policy. It doesn't go as so far as to say exactly what California says about you cannot feloniously, intentionally, and if you do, you're not a beneficiary of a will or trust, etc. What they do is it goes back to old England and common law days, and it's even in our Texas Constitution about blood. And so what they've done is or at least what we do here in Texas, is treat it like a constructive trust, a trust that that person controls, the one who committed the felony, for example, but they cannot use or change who the beneficiaries are. It goes to the others have a constructive trust for their benefit, the closest heirs other than him.
Interesting.
So, but the problem with that, at least in my mind, not that I've ever had any clients that have dealt with this, quite frankly. Yeah, they want to say kill all the lawyers, but
Yeah, right, exactly.
but in any event, the problem with this is if you have a constructive trust, the other heirs or beneficiaries have to sue to get the constructive trust. So if your estate is not large, will it be worth the attorney's fees? And so I think, I kind of usually I say I like Texas laws better than California laws, but I'm not sure that I feel that way in this case because
Right.
I know that what they want equity, the Texas Constitution going back to it's called the stain of blood in Old English times. And so there's the reason why we have adopted from England in our Texas Constitution. But I don't know. I kind of like the way that California does it better.
It
And
seems like Texas is more ambiguous and loose than
yeah,
California.
yeah. I mean, I don't want to have to. Why do you have to sue
Yeah, right.
to have a constructive trust? And so that
Right.
seems unfair because there's legal fees that are involved, um, and there's no remedy to get those legal fees back. So it just seems. This is just my own opinion. It
Right.
seems a little bit um, onerous.
Right.
I think I kind of like the way California's doing it better in this case.
I can't believe we're saying that we like a California law better than a Texas law.
I
How
know.
shameful this.
Yeah, I know. We always talk about California having a lot of issues that we don't have here in Texas, and that's
Right.
for the most part still applicable. But in
Well,
this,
it's complicated. It really is. And this is why I say almost every show, this is why you need to attend Michael's workshop. And the next one is sometime in January, February. Just call Michael 214-720-0102, 214-720-0102, or go to DallasElderLawyer.com, DallasElderLawyer.com to find out when the next workshop or workshops are so that you can be ready for the next one.
yeah, if you do go to the free estate planning and elder law essentials workshop, which is 2 hours, we're here in North Dallas, then you also get a free vision meeting. So you get 3 free hours without any obligation.
It's a private meeting, a
Yeah.
vision meeting. So you don't have to sit there publicly and air your dirty laundry. You can do it privately, which is nice.
Yeah, but we only give the free meetings, quite frankly, if you go to the workshop, because we could talk to a lot of people, kind of educate you at one
Good.
spot. So it makes it easier for
Smart.
us.
That's smart.
If you want to attend that next workshop, call 214-720-0102 or sign up online. Well, thank you, Don.
Thank you, Michael.